The Supreme Court of Georgia has denied Doug Weinstein's petition for writ of mandamus. Hold your horses, this is not bad news. The Supreme Court of Georgia is basically saying they must first file the petition with the Fulton County Superior Court. But this is not looking good for the trial continuing. I'm thinking the trial may be over within a week. Not even trolling. Here's the document right here. Supreme Court of Georgia, Diamante Kendrick, YAK Gotti versus Euro Glanville Chief Judge. Petitioner Diamante Kendrick, who is facing trial on murder and other charges in Fulton County, filed directly in this court an emergency motion seeking original relief in the form of a mandamus against Chief Judge Euro Glanville and a stay of proceedings, which means pause the proceedings and kick the judge off, basically. Kendrick filed in the Superior Court a motion to recuse Chief Judge Glanville after he became aware of an alleged ex parte meeting on June 12, 2024 between the judge, assistant district attorneys, a state's witness, Woody, and the witness's attorney, Miss Bumpus. Chief Judge Glanville did not refer Kendrick's motion to recuse to another judge, see Uniform Superior Court 25.3, and instead decided the motion himself and denied it. So what that sounds like is the Supreme Court of Georgia is saying that Judge Glanville fucked up. And here it is. They're literally citing where he fucked up. USCR 25.3 provides when a trial judge is presented with a motion to recuse or disqualify accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination assuming any of the facts alleged in the affidavit to be true, whether recusal will be warranted. Basically, the judge shouldn't have decided this himself. It should have went to another judge. If it is found the motion is timely, the affidavit sufficient, and that recusal will be authorized if some or all of the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. In his emergency motion, Kendrick does not seek appellate review of the order denying his motion to recuse. Instead, he seeks original relief from this court against Chief Judge Glanville, asserting that any effort to file a petition for writ of mandamus in Superior Court would result in the frustration and lack of action. Remember, they said in the petition that all writs die in Judge Glanville's court? Because such a petition would go to Chief Judge Glanville, and so he has no option other than for the Georgia Supreme Court to exercise his discretion and consider his claims. By way of relief, Kendrick requests that this court direct Chief Judge Glanville to adhere to Georgia Uniform Superior Court Rule 25.3 and assign his motion to recuse to an unbiased judge for a hearing. That the court stay the trial proceedings pending resolution of the motion to recuse, and that the court order Chief Judge Glanville to produce an unredacted transcript of the secret ex parte proceeding held on June 12th. Remember, the judge also was saying, I'll give you guys a transcript, but we're gonna have to redact some stuff. What? Why are you redacting anything? That is so sketchy. I can't believe that's reality. This judge is defying all logic in this situation. He should not be handling this recusal. Although this court has the power to grant original relief and the nature of mandamus, it has chosen to maintain its general status as an appellate court and to exercise its original jurisdiction only in extremely rare. Motion shall stand denied automatically. The trial judge shall not otherwise oppose the motion. In reviewing a motion to recuse, the judge shall be guided by Canon 3 of the Georgia Code of Judicial Conduct. Kendrick requested that a certificate of immediate review be granted so that he could seek appellate review. See OCGA 5634B, but Chief Judge Glanville denied the request. To support the claim, Kendrick points to two other petitions for writ of mandamus he says were filed in connection with this case, one in July 2023 and the other in October 2023, that Kendrick says have yet to be heard by Chief Judge Glanville despite efforts by claimant's counsel to have a hearing on the matter. So yeah, the judges ignored other writs of mandamus. One of them's a year old. That's fucking insane. So this is where the Supreme Court basically says they have to go backwards to the Superior Court of Fulton County. And before this court will consider exercising its original jurisdiction, the petitioner must show that he has sought and been denied access to the proper channels for seeking relief in a trial court. See Gay v. Owens, 2013 case, and Brown v. Johnson, Kitchens v. State. Moreover, it is well established that a petitioner seeking mandamus relief against a Superior Court judge may file such a petition in the appropriate Superior Court. And being the respondent, the Superior Court judge will disqualify, another Superior Court judge will be appointed to hear and determine the matter, and the final decision may be appealed to the appropriate appellate court for review. Here, before seeking original mandamus relief from this court, Kendrick is required to show that he first sought and was denied access to the proper channels for seeking relief in a Superior Court. And Kendrick has not made such a showing, as he admits that he has not filed a standalone mandamus petition against Chief Judge Glanville in Superior Court. Although Kendrick expresses concerns that filing a mandamus petition in Superior Court would be futile because the petition would be assigned to Glanville, that is not so. As explained in Brown, if Kendrick were to file a mandamus petition in Superior Court naming Glanville as a respondent, Glanville would be disqualified from presiding over the matter. A different judge would consider Kendrick's position, and either party may appeal the final decision. And then they cite Brown again. Accordingly, Kendrick's emergency petition for writ of mandamus and stay of proceedings is dismissed. And here's Doug Weinstein's Twitter. He says, note the portion that SCOG emphasized. If it is found that the motion is timely, the affidavit sufficient, and the recusal will be authorized if some or all of the facts set forth in the affidavit are true, another judge shall be assigned assigned to the motion. Phil Holloway says, file it tomorrow in Superior Court and he will have to refer the mandamus to another judge. Then if you lose, you get a direct appeal. If he refuses to refer the mandamus to another judge, the Supreme Court seems to say they'll handle it in that case. So that's basically what it says. The Supreme Court is saying that they would recuse Judge Glanville straight up. They're like, yeah, he fucked up. He didn't. They cited USCR right there. He fucked up and didn't file 25.3. Shout out Thugger Daily for tweeting this out. I want to read it. Woody posted this on his story. He is an innocent man. In real life, the demons that has been on me at certain times of my life had full control. It took years to break free of those demons. And now my conscience is eating me up. I'm not allowed to talk, but I pray to God that they pray and trust in him, that he reveals everything that's going on. Every single person that steps in that building have been violated. Jesus. And they show us time after time that they ruin everything. I lost family members, my kids, and at the point of losing my sanity. This is not freedom. This is a country that bullies others to comply. This is a country that takes what they want, and this is a country that will not stop until they get what they want. Now come lock me back up. I ain't scared. Now, this is going to be in the trial. If the trial continues, best believe the defense is going to put this in evidence and ask him what he means by bullying to comply, because that's basically what Judge Glanville did. Remember, Judge Glanville is being accused of coercing Woody to testify. Remember, Woody didn't want to testify, and then Judge Glanville had the ex parte meeting and told Woody that he could be held for years until everyone else is tried in the case. And Woody was like, that, yeah, I'll testify. Coercion. The defense is going to put this in evidence, I promise that. Also, this went viral the past few days. I didn't really talk about it, but whatever Wham says goes. So that's Lil Baby. Thug is basically saying whatever Lil Baby thinks about what Gunna did, that's what he thinks. And obviously Lil Baby thinks Gunna snitched. He said something in his song like, N-words taken please, I know slime ain't happy. Gunna took an Alford plea, so it's not really snitching. In my opinion, the jury, it's not going to affect the case. Gunna doesn't have to testify, so the jury's never going to see Gunna up there talking or anything. So it's an Alford plea. He's still saying he's innocent and everyone's innocent, but he agreed that it was a gang. So that's where like there's a line that he crossed a little bit, that you can't really speak like that in court in terms of like, you know, gang shit. But people are saying this is what sparked Thug to tweet this. Gunna saying this in an interview. I'm still signed to YSL. I'm still providing, like we still pushing, like no paperwork has been changed. You know what I'm saying? Whatever's been getting and how we've been pushing this shit, it's still going. So yeah, that was just controversy over whether or not Gunna snitched and Lil Baby getting involved now. It's funny, I wonder how the tweet gets sent out. Like, just does Thug just tell someone to tweet that? Like, I wonder how this happens. In jail with jail calls or something, like what? But yeah, I have a feeling the trial might be done within like a week. I know I said this like a week or two ago, but I feel like it's coming because the Fulton County Superior Court, they're gonna give it to another judge. And if the other judge doesn't recuse Judge Glanville, this shit's corrupt. Like, it's a fucking official. So that's just my opinion. Hit subscribe. Love you guys. Peace out. Another drink.